Well, hey, everybody. Thanks for being here. We do look forward to your questions, so please don't be shy. We thought it'd be helpful to start, before we dive into some show and tell and really get into the nitty gritty, think about a little bit of some of the bigger picture reasons why you might consider these tools and how we think about them. And the first thing we think about is, as Jim mentioned, self-represented litigants are not an exception, they're the norm. If you're working in civil courts, you work in high volume dockets, you know that the people coming to your court overwhelmingly are not lawyers, they don't have lawyers with them. And so that poses a challenge, but it's also an opportunity. And I think when you embrace that opportunity, what we try to think about is, how do people learn? And what are the ways in which we convey information? And how can we meet people where they are? And what I like about these tools very much is that it's a different style of learning, and it's a different way of teaching and providing information. And we think of them as supplements and augmentation, but not replacing other things. Person A, 10-minute video, they watch it, they're great, they're good, they know exactly what they're going to do. Person B, 10 minutes is too long, that video better be 3 minutes. Person C, they're never going to watch a video. They need it in writing, they need it in their hand, they need to hold it while they're going up to the clerk. And so these tools are a way to get to those people that are comfortable being online, which is not everyone. And what's really important about them, and the reason that we really like them, as you'll see, is that they're not just providing information, they're providing tailored information that is for someone's goals and circumstances. And that's a really big difference between how a lot of legal information is presented. If you think about that, that's a pretty important thing to say to someone, who are you, what's going on, and what are you trying to do? And then giving them information that matches those answers. That's a very powerful, informative way to get someone more comfortable with a problem, more comfortable with a solution, and more comfortable with a process. And so we'll get into this in a lot of different ways. Yes? Live stream's not working? Okay. Okay. So what you're going to see is just in time, just what is needed legal information tailored to someone's circumstances and goals. And I promise you it's not legal advice.
Awesome. Okay, so we are going to talk about alternative uses to guided interviews, but to make sure we're all on the same page, I want to introduce guided interviews. Raise a hand. Anybody ever seen one? Know what we're talking about? Awesome. You probably first introduced when we saw TurboTax, or if you've recently filed a passport renewal, they have a guided interview. And what they are online questionnaires that are simplified versions of form fillers or drafting a pleading. And they're great to take a complicated process like filing your taxes or completing court forms into kind of bite-sized questions that go step by step for somebody who's not used to completing that process. So we've seen them pop up in courts across the country. A few examples are in Clark County, Nevada, where they have them in a few different areas through Odyssey Guide and File. Jim mentioned my affinity for the Suffolk Lit Lab. They're in Massachusetts, available across the entire state, and have forms in all of the different courts, all the trial courts across the state, as well as the appellate court as well. And then Indiana Legal Help has a few where if you have a suspended license, you can complete the forms to reinstate your license. So they've sprung up as a really helpful way for somebody who doesn't have a lawyer or legal aid but wants to be able to take those steps and take action on their own. We are building one with Pulaski, Arkansas, for uncontested divorces with children. So it's a very specific use case. We have kind of a limited amount of forms that could potentially be filed in there. And we're working directly with the court to create those various pleadings. We work with the person filing, so the plaintiff, and the defendant as well, to complete all of the steps from starting the case to getting the order along with the child custody order. And so behind the scenes, it kind of takes some steps. We do a little bit of eligibility and triage to figure out what forms we're going to need to fill out. And then you take the forms or the pleadings and reorganize the questions in a way that makes more sense for a court user rather than the court. Because a lot of the times our court forms or pleadings are organized to give the court information, but filling those out doesn't always feel natural for our court user. And so the guided interview is the place to get that same information in a way that makes more sense for somebody who is needing to complete them without an attorney. So in about 10 to 13 pages, you go from filling out short questionnaires like this to completing a ton of forms. It can take you a long time to complete those forms, those pages, but at the end you end up with a complaint for divorce, a summons, the confidential information sheet, so like your social security number and things like that you might not want to enter directly on the pleadings that are public information, the required civil cover sheet, and also not pictured here, we have an information instructional sheet of how you then bring all of those things to the court and send them to the other side. So it's digested a really complicated process. I'm not sure that any litigant can sit down and write a complaint for a divorce on their own, but by going step by step, you complete a really complicated court process. And that's a big benefit to a court user who might not have the need or even means to have an attorney. Legal aid is not always available to complete all of those steps. So it's a big benefit to our users who can take the matters into their own hands and go through the process. But it's also great for the court because you're getting better pleadings, you're not spending time rejecting them, or you're just getting better questions. Your court users come in, they're prepared, they have things, they might have questions about it, but they're like 15 steps ahead. And they're also they're getting more accustomed to the court, and they feel like they've had some control and some power and have an opportunity to express what they needed to in a time and a space that they're comfortable with. It can be stressful to do this all in a courthouse and standing maybe at a little counter and writing it down. This you can do anywhere on your phone, at home, middle of the night. It's going to be available full time. But we're also thinking about other ways to use this technology that's not just creating and drafting forms or pleadings. And Andy is going to introduce that.
Yeah, so as Aubrey mentioned, these are some of the more traditional use cases that we're familiar with for guided interviews, but our session today, we really want to show some alternative ways to use these that provide different benefits for you. So what are the other uses? One of the first ones is about navigation and orientation. So this is maybe the court user who has a specific question about their court case, like I have this document, what do I do? And so that you can find out what stage of the process they're in and then tell them what steps to take in order to move forward with their case. Another one is eligibility and triage, which Aubrey briefly touched on. That's where a court user might come to a court website and see, 5 different ways to resolve their case. However, maybe only 2 of those apply to their circumstances because of the nature of the citation or whatever it may be. And so eligibility and triage can say, based on your specific circumstances, here are the options that you actually have. And then the final way that we're going to talk about today is informed education and actually understanding what you're doing in your court process. So, a court user who comes to a court website, even if that court website has all the information they need, they're kind of seeing it all at once, or they're having to click through these tabs and try to decipher what they need to do. And so instead of giving them all of the information, we can say, okay, it looks like you have a problem with language access. Here's information about how to get an interpreter. And so it's really just a way to funnel the information into a really digestible and understandable format. And now Zach's going to talk about some of the more tangential benefits that aren't directly from these guided interviews, but that come as a result of doing these types of projects in your courts.
They give me the hard stuff to talk about. I don't need that. So there are a lot of things that you can see immediately as beneficial, but here's a couple you might not have immediately occurred to you. First up is if you're doing this right, you're getting those better questions or you're getting fewer questions, that can help you with your staffing decisions. If the number of phone calls with the same question goes down, if the number of people showing up at the clerk's counter with better prepared filings goes up, if the number of questions at the clerk's counter goes down, that might free up staff to do other things or different things, or you might think about how you staff differently. And this can be really powerful if it's done right because of that. There's also an underlying sort of Trojan horse element to this. When we work on one of these projects, we're looking at a process in a court. And so while we're trying to build a guided interview at the end, along the way, we're getting some really valuable information about a process. What's working, what's not working. Are there parts of that process where everyone always gets stuck? Some of the courts, we might end up building a guided interview, but along the way, they might also end up changing some procedures because they find out that there's a lot of issues there that could be resolved, and the guided interview might be able to help with that, but better still is changing policies and practices. You all probably know this intuitively, so I'm going to name it for you to have in the back of your mind. We are in a battle for attention. There's a lot of information out there. People are going to go where they're going to go, and they're going to find what they're going to find. And what you want is for them to find the good stuff, the verified information, the trusted information, preferably the information that you put together. When you can order a pizza on your phone through an app from a company that tells you exactly where that pizza is within a few feet of your house, you got to look pretty credible to compete with that, right? Because they're going to find stuff on the internet that looks pretty credible, even though it's total garbage. So if you can put together something like this that is coming from you, your court, to the user, it's trusted as an information source. It has that veneer of whiz bang to it, right? It's guided interviews. It works on your phone. It works from home. It works on your computer. It looks nice. That boosts your credibility. You might be the most credible source, and I hope you are, but you might not be the one they find, right? So if you look credible and you are credible, you're in much better position than if you're fighting with ChatGPT, some YouTube video some guy put together. People are going anywhere looking for anything. You got to win that battle for attention. And then I mentioned this briefly, and I just want to reinforce that this is also useful in thinking about that, walking that line between legal information and legal advice. You can give a lot of information, a lot of tailored information, a lot of circumstance-specific information that is not advice. And what we typically do now, unfortunately, is we think about every possible situation that someone might encounter. We put all of that in a PDF, and then we put it on our website. That's too much. It's a lot, right? If I'm getting divorced and I don't have children, I don't actually want to know anything about child support and custody and parenting plans. In fact, seeing it is confusing. So if I ask someone that simple question, do you have children? And they say no, then a guided interview can immediately reduce the amount of information they have to wade through. So be thoughtful about how you provide that legal information, because you can do a lot with it, and you can do a lot of it in a tailored way that these types of tools can really help with.
All right. So if you're not convinced yet, we'll show you a few that we're building. So I'm just going to introduce two that we're doing in the Philadelphia Municipal Court. Andy is going to show you one that's their debt collection cases, but I'm going to start off. We're working in their landlord-tenant court as well. And so this is Tilda. Tilda is the tenant-landlord digital assistant, and Tilda is going to help us with our landlord-tenant case. Instead of doing a live demo that neither you nor I have the patience for a live demo, I'm going to show you screenshots. And just so you know, between these, there's often like 1 or 2 pages that choices have been made, but we'll get kind of the idea going. So Tilda is a digital guide dog that helps with non-payment of rent eviction cases in the Philadelphia Municipal Court. And we picked these cases because they are high volume dockets and have lots of self-represented litigants. And Philadelphia courts kind of said, what can you help us with? And so we had done some work on their website, and we were like, well, what else can we do with the information that you have available? And we created these tools. So instead of form filling and pleading creating, Tilda does not actually do that. What it does is orientation. It brings you along the path or the potential paths in a landlord-tenant case for both a landlord or a tenant who does not have an attorney, and helps you figure out what's going on. For people come into the process at very different points, and you don't know what's happening, and it's going to be kind of like an over-the-counter interaction, but online. So again, it still does some of those similar tools, doing triage and eligibility. So who are you? I need to know which path to send you down. Are you a landlord or a tenant? We're going to be tenants today. And do you live in the property? Because if you don't, if it's a commercial property that you're being evicted from, we don't have the right resources for you. And then where are you at your conflict? Are you arguing verbally with your landlord, or did you get a document in the mail, posted at your home, texted to you from your landlord? Or do we need help with that? So we're going to skip to a document, but there are some resources that Philadelphia luckily has for before it's at the court. They have required mediation, and we could go down that path as well. We're going to be tenants who got a document in the mail. So one thing about Philadelphia that made this really possible is that they have standardized forms that go to their tenants. So a landlord fills out a pleading, and then all of the eviction or the complaints that go out to a tenant look exactly the same. You're not getting kind of a customized document that's written by the landlord's attorney. So that was really helpful that all of the pleadings are standardized. And if I'm a tenant and I can either match the name that's right at the top of my legal document, but if I might have trouble with that, you can also see the blue hyperlink next to each of these. And you can see an example. So the court kindly drew us up some Jonathan and Mary Doe examples. So a tenant, if they're not exactly able to match what they have in front of them, can see some pictures to find out, okay, this is the document that I have, this is the right choice to make. We also, below from that last screen, have these kind of drop downs where we do some education. So if I know that I have a landlord-tenant complaint, but I want to know what that is before I keep moving forward, we do some brief explanations here. But we're going to do some more education as we're finding out what information to be giving someone. Because like Zach mentioned, it can be really overwhelming if I educate them on every single choice on this page all at once. It's too much. I start spinning. What's going to happen? What if I get a writ of possession? Like that's way down the line maybe if I only have a complaint. And we don't want to stress people out. We want to know where they are and give them the right information. And so that's what Tilda does. Now I know that you have a landlord-tenant complaint, and I'm going to walk you through what it is. We tell people you need to read the whole document, but the next few pages help them find that most important information. So who's being sued? Find your name. Are you on the document? Is it everybody in your house or is it just you? Is that your landlord? It might be a company because your landlord might be a company. Doing some education. And then explaining to them terms like what is a demand for possession or a demand for money judgment, helping them understand what the landlord is asking for. And then we come kind of the third important place in the summons and complaint is finding their court date. And this is a really important, like our first really important intervention step is getting them to court. So we make sure that they're actively entering in their court date, and then we prepare them. How does one go to court? This is where the court is located. These are the things that you should bring. Just information that you need to know. That's all available on the website, but it's among other things. And it's just about exactly where you are. And so down here we have a document that they can open for a little bit more robust information that's specifically about where they are. And we have this is a few steps ahead, but make a plan to go to court, and then what is going to happen at court so that they are doing some expectation setting. They know the conversations that are going to be had. It's not preparing them what to say, how to win in court. It's just what is going to happen there. So maybe a little calming, a little like you could show up and you know exactly you're going to have to talk to the landlord before you talk to the judge. So that could be jarring, but if I already know that, I'm prepared. And then, so what if we go back? What if my court date is in the past? So I have a summons and complaints, the only thing I have, but it was a month and a half ago. Tilda's also prepared for that. So did you go to court? Well, maybe you did. Okay, so then we should have a new document, and I want to know what that document is. Maybe you just didn't walk out of court with your judgment that day. It tells you how to go online and find it. And then also does, again, some more education. What do you do with a judgment against you? What do you do if you won? What does a judgment by agreement mean? Which is where they come to an agreement at the court, but it's still a judgment. Doing some more education about those steps that could happen down the line. It's also a great place where you could just play with examples, right? It's kind of like a choose your own adventure. So somebody might not be at this point, but could have also gotten here and is just learning about all of the different paths that could happen with that court. And so this lets them skip ahead. So like, to go find your judgment, like you need to know what's happening and we'll explain that to you. But what if you didn't attend your hearing? They'll know, default judgment. And we need to skip ahead. And we skip way ahead. You can see actually my guide dog has moved to the way end really quickly and is red, it's an alert. And what are the possible things that happen? You could have a default judgment. You need to go on the court website and look it up. This is how you go and look it up. This is what it means. And then there's a few options here. It's you can abide by the default judgment and maybe move out or pay the things that, pay the back rent that has been the due, et cetera. You can follow your judgment. Or the other option is if you want a hearing, you can file a petition to open. And it's not making any of the decisions for someone. It's again, these are the two things that you can do at this stage. Make your decision, but make an informed decision. And again, it's only that world right here. Because if you go on the website, it's also going to talk about an appeal. but this isn't the right time to talk about an appeal in Philadelphia. And just figuring that out is so challenging. And then going to actually file that appeal or the petition is challenging. This way, it's only the information that you need at that time. One thing I will point out is, where did these sheets come from? We actually made them. One thing that we found that I think is maybe true not just in Philadelphia is that there's a lot of information there's all the information that you need to use, but again, there's not that information how to use it. It seems like we think that court users are going to get to court, they're gonna come to their first appearance, and then they're in this magical world in the courthouse that they're gonna have all the information they need from that point forward. But we know that court users don't always show up or get the information that they need. They just leave the courthouse as soon as they can because it's very stressful. There's kind of an information cliff that, okay, everybody gets to court, there's no information about what happens after that. So they have like the petition to open and all of the proper forms online, but there's information about how to get to court, how to prepare for your first hearing, know what to do. But then what after? What do I do after with a judgment? And so we found some places that Philadelphia can add more to their site, and it was really great to help them build that. And this information doesn't have to just live in Tilda. We can take the dog off and basically put up a few more pages, and it's the same information that somebody needs. But what's great about it being in Tilda is they are only finding that information when they need it because they've been able to interact. And the last thing I would say, again, is we're not making decisions for people. These are some of the kinds of screens that we've skipped over. So do you want to stay or do you want to move out? Do you want to file an appeal or do you want to follow the judgment? Again, these are the conversations that you would have over the counter and talk to people about. And we're letting our user have that same interaction just at home with the information in front of them in a not stressful place, where they can maybe think about it a little bit longer and come into court prepared. It's also really great, I think, for the court. They have the court user come prepared and know about some of those things, and maybe again have good questions or need explanations, but they've maybe gone through the adventure on their own and tried to figure it out a little bit. I think Andy's going to show you what we're doing in their debt collection.
Yeah, I have the easiest job because Aubrey has set up this world that we've created for you, and now I just get to talk about a different way that we're approaching it. So Cody is the debt collection version for Philadelphia Municipal Court. And it's a little different from Tilda in that it doesn't necessarily follow the whole lifespan of a case. It's really looking at a snapshot in time of when that user finds this tool and engages with it. So it starts off by welcoming them. Then we have a screen that it asks them if they needed reasonable accommodations or language interpreters. Currently, it exists as an English-only tool, so it lets them know that and say, hey, if you have made it this far, you've found us, then call the court and get some language assistance. It then asks if you're a plaintiff or defendant and educates about what that means. And today we're going to go through the defendant path, just because in debt collection cases, there's only about 2% in Philadelphia who are self-represented plaintiffs. And we do have information for them about how to file, how to get to the first filing unit of the court that will help with those documents. So we're not just doing this one-sided, but today I'm going to show you the defendant side. So similarly to Tilda, the way that Cody diagnoses where you are in the court process is by understanding what forms you have. So we ask them if they have papers from the court. If they don't know or they say no, then we educate them about how to find it on the online publicly available documents so that they're able to see if there are documents with their name on it. If they answer yes, then we start trying to figure out what form it is. If they search for it online, then they link back up to if they had said yes at the beginning to kind of walk through their form. So also, as Aubrey mentioned, the standardized forms, with the debt cases, we were typically looking if they had a statement of claim, which is, kind of like the summons, and then a writ of execution or a judgment letter. We show them what that looks like, and we also do a little bit of education of if you have this form, this is what it's telling you. And then we're going to walk through and kind of read this form with you so that we're really demystifying what it's saying. So we ask about the statement of claim first, because if they have that and nothing else, then they likely have an open case, and we can start asking about what's on that form. If they have a judgment or writ of execution, then it's likely that they have a default judgment, and we're going to give them information about that. There's another place in the statement of claim branch that gets to default judgment, so I'll show you that later. But it's the same basic information that they'd receive if they answered that they had a writ or a judgment at this point. So Cody really tries to help court users read their forms, and one really important thing for cases in general, not just debt collection cases, is the timing of where they are in relation to when their court date is. So one of the pages that does a lot of the heavy lifting for this app, we ask them when their hearing date is scheduled for. This is the point as well that if they say a day that's in the past, they're going to get put onto the default judgment path. If it's in the future, then it also has the ability to calculate how much time in the future to see if they have time to file a petition to, or a continuance, or to ask to reschedule their case. So that's an example of, all of this information is on the website, but if you're getting it all at once, it can be really confusing. But if Cody can tell you, like, with how many days you have left, tell your case, what options are available. And then the other thing that I wanted to point out from the form is we ask what hearing room they're in. And the reason for that is because in Philadelphia Municipal Court, if you get scheduled in hearing room 5, that's actually a pre-hearing room where there's no judge. You are likely going to be negotiating with the plaintiff attorney and trying to come to what's called a judgment by agreement. Yeah.
A question online is, was there consideration for the reading levels of the people accessing the tool?
Yeah, I'm so glad someone asked about that. Anyone familiar with the center's work? We are obsessed with plain language. We will talk about it no matter what project we're working on with you. And so we use just a free online Hemingway editor app to check our reading levels. And for the majority of the stuff we write for these things, it's taken from the court's website. And then we tweak the language a little bit and try to get it down to about a second or third grade reading level. The recommendation is it should be at least a 7th grade, or like at most a 7th grade reading level. And so we're checking for that. And then even with some of the things where we're putting in the technical language that they're going to see on the form, we're trying to provide visuals so that they can say, okay, I'm supposed to look at this place. So even if the wording is still confusing, they get that visual companion to identify. So yeah, I hope that answers the question. And we'll touch more on plain language at the end and as we talk more about the forms. So yeah, if they answer that they're in hearing room 5, their first court appearance is going to look a lot different than if they're in a trial room with a judge. And so that also helps us narrow down what information we show to them. So if they say that their hearing date was in the past, then Cody tells them, okay, you may have a default judgment. If you do, you'd be able to find it online. It can show them how to find it again. And then it tells them what it is. So doing that education of, we think you're at this point because of the answers you told us. If that's true, here's the information you need. So it's also going to ask about if they knew about their court case, if there are certain reasons why they would like to engage in this case but didn't, so that we can once again kind of inform them about the options that they have based off of that. So for people who have a default judgment, this is kind of where Cody's process ends for them in giving them information about what a petition to open is, why you might want to file it, and then providing information on how to find legal help if you need it. Because once again, Cody's not filing any of this for you. This is kind of its information cliff of like, we've identified where you are and have told you what you need to know, but you may want to engage with the court or with legal aid at this point. So that's what this is showing. For people whose court date is in the future, we then provide information of, okay, sometimes we understand that you're not going to be able to make it to your court date. Here's what you need to do if you already know that you're not going to make it. Then we tell them, okay, traditionally in debt cases, these are the requirements and things that you should be aware of. And we're trying to give them the tools to be able to have an educated engagement and conversation, both with the plaintiff's attorney and with court staff if they come to them with questions. And at this point, I will mention as well that our tools, we have done user testing with them as well and engaged with stakeholders in the community. So we've had plaintiff attorneys, defendant attorneys, court staff, city council members, law professors. We have them look at it to make sure that the information we're telling them is correct and that it's also just tonally that information instead of advice. We're telling them this is a snapshot of the ecosystem and the procedure, and then this is where you fall in that process. So once they answer those questions as well, they see that they're done and they're given an opportunity to download a customized printout that tells them the information that they need. So the first page is very much just, okay, we want to make sure that you're engaging, you're going to court. So, this is a picture of the courthouse. The entrance might be confusing, but go in there. That's where it is. Also, information that they put into the tool is on this sheet so they can see the date, the time, how early they need to be, whether to find childcare, how long to expect to be there, just kind of the common questions that they might have come up. And that was all pulled directly from the court's website. The other thing that this cover page does is it lets them know. So in the use case I'm demonstrating on this, they said that they're in hearing room 5. So what does that mean? What's a pre-hearing room? What am I gonna see when I get there? Because it's not gonna be, the legal procedure that they see on TV or may be familiar with. And then the rest of the printout kind of digs into that and gives them more information. So if they stopped reading at that point, we hope that they at least show up to court, that it's not an automatic default, because that creates a lot of extra work for the court as well when they're having to follow up with these defaults and file the additional paperwork. So in this one, you told Cody that you're in hearing room 5. Here's what that means. Here's what you should be prepared to talk about. Here's what happens if you do make an agreement. It is legally binding, just like a judgment from a judge. So once again, just informing them of what their decisions mean, as well as what options they may have. So that is, in a nutshell, how Cody works.
Okay, one more. So we also work with Salt Lake City Justice Court, their traffic division. Similar ask, high volume court. Sorry. But so the other thing was happening was they're showing up in person or to the online arraignments and then being diverted to these alternative programs, basically wasting the court users' time and adding to a longer docket that didn't need to be happening in Salt Lake. So we're trying to figure out exactly why both of those were happening. And we started with their website where people could find information about these programs. And this is a snapshot of their current website and the information that is there. It is actually relatively thorough and has all of the information, but understanding that information and determining whether you are eligible to participate in these programs and what it means for you can be challenging. So while Maybe we as kind of experts understand that this is all the information somebody needs. We need to draw that out a little bit more, break it down, put it on some new pages of a guided interview. And so we built TRIP, which again is the Traffic Resolution Information Platform. We love the nickname. And it is both an eligibility tool to understand, you can go through and figure out if you are eligible for those programs, but also an informed decision-making tool. So is that the choice that I actually want to make, and what does it mean for me? Again, this tool does not actually enroll them in the program. It's not the payment portal. It is none of those things. It is just to help them understand the information that was on this slide. And so it does, again, some of these, where do we want to go? What kind of ticket what kind of citation do you have? And ask them those questions that the court would ask, the JA would ask to figure out whether they're eligible. So for example, the first one, does your citation include driving under the influence DUI? DUIs are not available for any of these. You need to schedule an online arraignment. But TRIP would then help them find that page, make sure that they're all set, know when to go to court for that. If it's a parking ticket, also you can just go to this one other place. But if it's a moving violation, that's where we're gonna move into some of those questions. Like, do you have a Salt Lake driver's license? Are you over 21? Some of these questions are pretty easy. And then some of them get a little bit more complicated. Like, is this your first infraction in the past 5 years? That can be a little bit more challenging. And you can say, I don't know, because we'll just tell you, you're likely eligible with an asterisk, and this is the information about it. And then we kind of move into some of the more, the decision-making that Andy can kind of talk about. That is really the fun part of this one.
Yeah, so, so we are asking questions about eligibility and trying to triage for them and decide how to sort them into where they might want to go. But we also want to know how the court user would like to resolve it. We want their, sorry, was that a signal? No, okay. So we also ask them, do you want to just pay? Did you have a speeding ticket? Do you just want to pay and be done with it? And if they're seeing this, it's likely because they're eligible, because they've gone through some of those initial questions that Aubrey was just showing. But then sometimes people may not fully know what they want. They may think they know. So we want to do some education of if you make this choice, here's what that means. If you just pay your citation, that's the same as taking a guilty plea. You're also going to get points on your license. Here are some of the things that you may not think about by saying, I'm just going to pay and be done. And so we still want them to be able to choose what they want to do, but we want to make sure that they understand what they're choosing. And so even though this doesn't take any actions for them, if they see this information and then say, yeah, I want to accept the conviction and pay the citation, then the next page has the link to the court's website. That's the payment portal. So it's walking them through the information in the guided format and then kind of spitting them out on the court website where they need to be. So because this one is so self-contained in the kind of process with the Salt Lake Justice Court, if they choose things like paying or things that are hosted on that website, we can just automatically redirect them to that place. So we're hoping that with educating about the consequences of different resolution types, court users will be able to decide for themselves and make the right decision for themselves. So as Aubrey mentioned as well, sometimes they may not know, okay, my citation or my charge number might be a mandatory appearance, but I don't know. And if that's the case, then we tell them, you might be eligible for this. And so it's not saying definitively you can do this program, go and tell the court. It's saying based off of all the information that you know for sure, these are the potential options. And then once again, making sure that they understand that they can request an interpreter, get ADA accommodations, and then where to find more information if they still feel like I'm not quite sure what to do. and throughout providing the phone number to the court in case they end up calling. And even though the main priority is to reduce that call log, we're hoping when people do call, they'll have more targeted questions for the judicial assistants so that the time spent on calls is also reduced. Zach, I think we're back to you.
Let's back it up one slide or something.
Oh, yeah.
Thanks. So let's get selfish for a second. We've talked a lot about how we can help court users, and I think these look deceptively simple, but when you really think about what's going on there, we're doing a lot of behind the scenes routing and triaging and moving people in ways that's helpful for them and helpful for the court. But these tools can also help you and your court. For example, in a matter of weeks, we're going to be releasing one called the Appearance Rate Report Card. Who here has trouble with people not appearing in court? Failures to appear, default judgments. It's common, right? So we've got a lot of great guidance on that. But what we've done is we've tailored it to your court and your jurisdiction and your specific interests and policies that you might have the ability to change or control. So with this guided interview, which we're building and launching soon, you'll be able to tell the tool about your court and your interests, and it will tell you about strategies and ways to increase appearance rates. We got another one. We don't have a cool nickname for this one yet. Many jurisdictions are changing debt collection policies by legislation. Courts have to implement those changes, and that's challenging. So we're building another tool, which currently is called the Debt Collection Reform Implementation Tool, that will let you think about what those policy changes look like, what your court's opportunities and challenges might be with implementing them, and give you guidance and best practices and examples from around the country about how to put those policies into practice in your court. An oldie but a goodie is the Eviction Diversion Diagnostic Tool. I don't know if any of you remember this one from the kind of the height of the pandemic. We released this because courts were going, oh my God, we got to do something about the pending wave of eviction cases. And diversion programs were a hot topic, but not many jurisdictions actually knew in practice how to set one up. So again, by asking you tailored questions about your jurisdiction and what was possible, we were able to help hundreds of courts around the country get better advice and practical guidance about how they could implement a diversion program in their court. And we gave them examples to work off of and guidance and cheat sheets. So what I really like about these tools is it's not just for the people, it's for the courts as well. And it's not changing the world via very complicated AI or some sort of whiz-bang technology that you may not be able to understand, may not be able to pay for, may not be able to maintain. This is simply giving people the information and choices based on their context and goals. Did you have a question? Oh, can you wait just for the mic? Sorry, for the people on the stream.
I'm curious, are you developers? Are you court, professionals, or both? And how are you getting it developed? Because, I could walk through this process, but to get access to the technologists to be able to develop it is the challenge for me.
Right. So we prefer the term geniuses. That's another nice thing about these tools. There are many different vendors out there that offer these. We're using a platform called NetDocuments. What we are people who are experts in thinking through court processes. What Andy and Aubrey are particularly good at are building these sorts of tools. Aubrey built some of them before. Andy, I think this was your first go-around when we started building these at the National Center. And Andy's very smart, but so are you. And I think you could probably figure these out relatively easily. They're not requiring code. They're no-code solutions. And it is very similar to a SurveyMonkey sort of experience, where you're building these blocks with if-then logic, and sort of if someone says this, then they go to that. If they say that, they go to this. So it's reliable, stable, tried and trusted and true technology. But if you use it the right way, you can get some pretty novel results. And I think what we're finding with these. Thanks for that question. Great one. And then the last one I wanted to highlight that's for all of you in this room is some of you might also be familiar with the Justice for All project, which was a multi-year effort to really help courts think about how they fit into an ecosystem of providers in the justice system in their jurisdiction. And because it's a multi-year effort, that means we've got multiple hundreds of thousands of pages of guidance and reports and feedback and different stakeholder groups and all sorts of things. And so we're trying to practice what we preach and give you the same experience we'd like a court user to have. Rather than giving you all that in giant PDFs, we're distilling all that learning. We're putting it into these guided kind of online tools and allowing your jurisdiction to tell the tool about your needs, your goals, and what you're interested in. And then we've taken 5 years of learning, multiple jurisdictions and experts, and distilled it into an online experience where you can get guidance related to your goals and interests. So another reason to really be sweet on these kinds of practices, because you can get a lot out of it without needing to become a coder, without needing to spend thousands and thousands and thousands of dollars.
Sorry, I turned my mic off, but it's back on now. I think now that you've seen some of these tools, some of the other benefits that we've discovered along the way that we can talk about. With Cody, you saw the cover page telling them when their court date was, how to get there with the picture of the court. That may be something that you want to do on your court form, but the process to changing court forms is so hard in a lot of jurisdictions. We've seen that. And as we've kind of done a lot of work with form redesign, we found there's some challenges that there are just rules that courts have about their forms. That's basically doing the same thing. It's taking their information that they put in and saying, this might be an easier way to digest this. Here's a picture. Here's where you need to be and when. And then here's the information you should know before you show up. So it's accomplishing the same thing that we want our forms to do and that we ideally would do in form redesign without going through kind of the administrative process of actually changing the form. Another thing with Salt Lake, with the ecosystem level view of the process, we were able to connect people from the state program to the Justice Court program so that there's more communication about these two programs that accomplish the same thing but are hosted in two different places. So it's really an opportunity as well, as Zach mentioned at the beginning, to connect people, to get a sense of how the process actually works in your jurisdiction, and then making sure all of the right people are talking to each other, which, you know, we'll step out at that point and say, great, now you all talk and you can make probably better solutions because of it.
And I think maybe just the last thing to add is the process of building these, like if you want to really take the time and go through and give yourself an audit and figuring out what you do have, what you need to replace, and what you don't have. Because even if you're not going to go and build one, if you just are thinking about it, and you can see if you're ready for it. Jim, you asked me, don't people love these in chatbots? And I think people do love them in chatbots. But one thing is that you need to have a place to direct people to, because you saw how long those information sheets are. You don't want to read that in a little chatbot. You need to have a web page that has it. And this was a great way to create a tool and content for some of those web pages that didn't exist, because also web pages serve a lot of different audiences. This let us think about one of those audiences, create materials for that audience, and then it could be regurgitated and reused and turned into a chatbot maybe someday. And it's just a great opportunity to really understand what you have and how people are using it. And that includes yourself and your staff as well. Maybe your staff would love to have one of these sheets to slide across and or give when somebody comes in to make sure that they feel good about that interaction. But I think there's a lot of just tangential benefits that you get in going through these experiences and building it, and then for your users. And close out.
So who wants some quick tips on how to do this really well? And you can scan that QR code. Those are our email addresses. We're happy to help you. So please don't be shy about reaching out. So the first thing is you got to choose the right process, right? Think about your high volume dockets. Think about the ones with the most self-represented litigants. Think about where it'll have impact. Where are you currently getting bottlenecked? Where are your clerks getting frustrated? Where are people getting frustrated? Picking the right one is really important. And you need to have an evaluation plan up front and early. In our particular instances, we're working with the courts now to gather data as a baseline. How many calls do you get? What websites do people go to? Do they download these forms? What kind of rejections are we looking at? What are the filings looking like? And then we're going to collect it after they've been launched in the field for a while and see, did this stuff improve the experience of the court user? Did it help court staff? Are filings better? Are questions reduced? Are questions better? Having that baseline conversation up front and establishing what you want to collect, really important to get going first. And also with these jurisdictions, sometimes you're thinking about replicability. What kind of process are you modeling? And could you take this with a few tweaks and put it in other courts in your jurisdiction or in your state? If you're at a statewide level, is this applicable across different jurisdictions in your state? These can be really replicable tools. Because they're built with no code, it's usually as simple as hitting a button somewhere in the software saying copy, and then you modify. Maybe there's a couple small tweaks. So it's replicable. And of course, you got to market it, right? You need people to actually find it and use it. So if you're talking about traffic tickets, work with law enforcement. Can they put a QR code or an insert or something that comes along with the citation so that people are finding this early? When you're selecting your vendor, what we don't want to have happen is after you've signed a contract, then start asking questions like, who fixes this when it breaks? Who's in charge of maintenance? Who owns the data? Or who doesn't own the data but has access to the data? Who can sell the data? Who can't see the data? All those are the questions you need to ask well in advance of selecting the vendor and well in advance of signing a contract. We put together a couple tools on our Access to Justice site, which you'll find from the QR code. One of them is contracting for digital services that really lays that out. And lastly, there's something you can do which costs you nearly nothing that will automatically improve every single one of these, and that is to user test. Here's my cheap, quick, and dirty way to user test. You need 5 friends who don't work in the court. The best friends are middle school students, their neighbors, there's someone from your pickup basketball league. They have no idea what this stuff is about. Say, can I borrow an hour of your time? I'll buy you a coffee, or we're just good buds. Please do me a solid. Take a look at this and tell me how it works for you. Which parts made sense? Which parts didn't make sense? Can you go through it and complete it? Do you have questions along the way? And all you got to do is watch and take notes and then debrief at the end. An hour, 2 hours, 5-ish people. If you only did that once, every single one of these that you produced would be infinitely better than if you didn't. And this is also a way to get those stakeholders involved. Along the way, we included, as Andy mentioned, people from the legislative branch. We included people from the law enforcement community. We included people from a statewide office, from a local office, internal, external stakeholders. They're building it together. They're ensuring it's accurate. And then if you user test on top of that, you've now got a community invested in this tool, and you've got a community that's put input and feedback into the tool. So the end result is something that everyone is appreciative of, everyone had a hand in helping build, and it's one that you know meets the needs of your users, whether they be your court staff for some of those internal tools, or whether it be the court user for some of those external facing tools. So I think we've got a whole 4.5 minutes left for questions.
We got more than that.
All right, more than that.
Okay, questions.
Let's hear 'em.
It strikes me that these processes, or any one of them, is pretty labor intensive in the development or analytically intensive, that it looks like it would be a much longer development process than many courts might initially think they are, in terms of, as you were saying, baseline data, element identification, gathering that data, people going in and changing the verbiage to match the individual municipal or superior court, because everybody has different terminology, and then coming back and refining that decision tree based on the feedback, both good and bad, that you get, so that you make it effective. Do you have any comment on how long this is going to take, and give courts a realistic estimate of how long it's going to take until they get to a smooth running operation? Definitely.
So I'm not going to lie to you and tell them that they're easy and you can stand one up, but I will tell you that, like, for an example, some of the ones in Massachusetts were stood up overnight. Those were built by developers, but it is possible if you know your process and are ready to run with it. So for example, some of the ones that we built, the landlord-tenant one does every single thing that can happen in a landlord-tenant case. That's a huge undertaking, and it did take us a long time. It's taken me about a year. But I also came into Philadelphia not knowing a thing about how their landlord-tenant cases work. I actually came straight out of law school, so I knew nothing about how landlord-tenant cases work. But that was a great opportunity because I got to audit it and say, where are the questions? And that was a lot of the time pre-building, before I even started building, mapping, understanding. And when you're building it within a court, you have some of that understanding. I would encourage you to do that part of the process so that, again, you have that experience of finding out where your blind spots are. But once when you know your process, you can map that out and think about what you want to build relatively quickly. Again, these tools are low, no code. Andy learned how to do it and has built like an incredible one that works well. He's done like a ton more customization than I actually know how to do. And so I think you have to be dedicated to it, but I actually don't think the development of the tool, the technical part, is not what takes the longest time. It's thinking about what you're trying to build and what you're trying to accomplish with them that takes the most amount of time.
Yeah, I think one of the benefits of having, the courts as partners is you have the institutional knowledge. We're coming and looking at the system as a whole and seeing it kind of big picture, but you live and breathe this every day. So you know the information, and the more engaged you are with the process, the faster it'll go. And I think there are, that's also discussions when you're scoping out the project. Are we changing our CMS and incorporating it in there? Or is this a standalone tool that we're going to offer as a link? For all of these that we showed you, I believe they're all standalone links. We aren't contracted to mess with the CMS of these states and of these courts. Sometimes I think we wish we were, but at the same time, it's very easy to do these standalone links and then pull from the court's institutional knowledge to make it happen.
I really, really appreciate that question, because to me, what that really underscores is it is really challenging to build this. It does take time, but the alternative is that we're acknowledging how challenging, complicated, and hard to understand these processes can be and doing nothing about it. And I'm not suggesting you are. I'm saying that like what these offer is an opportunity to acknowledge that and then do something about it. And what we do on the back end is fairly complicated, not from a coding perspective, but from really understanding and digesting that process. And it's worth acknowledging that if we're not doing that, what we're doing is saying that's you, the court user's problem. We do have that institutional knowledge. You have that institutional knowledge. This is a methodology for displaying that information in a different way. But again, it's a way that understands it, and it lets the user understand it in a way that meets them where they are. And to me, that's the whole value of these things. So again, thank you for that question, because it really, to me, gets to the heart of the issue. These are complicated processes.
My question is, did you get any pushback from lawyers reading it? Because we have a great law library and they put together great packets for self-represented litigants, but they tend to want to include high language because that's what the statute says. And so I'm wondering how you worked through those challenges if you face them.
Yeah, I can start. So I think I like that question because it shows once again the need to engage all stakeholders in this process. We don't want to come in and say, well, we worked with the courts, and so now, family bar, just do it because we said so, And so I think getting input from all of the stakeholders throughout the process is really key. And then back to the plain language stuff, we generally took the language straight from the court's website and then just edited it down to be more understandable and showed them, here's the reading level that we started at, here's the reading level we're at now. You can tell us if it's not saying the same thing and we'll fix it, but we think it says the same thing. And then oftentimes too, if you just throw a citation to the code in there as well and say it's saying the same thing, we're citing to this place, but we're saying it in a digestible and understandable way for the court user.
Mm-hmm.
Yeah, I'm a big fan of the sort of change memo. So here's what you had written before, here's it redlined, and here's it clean with a kind of, couple paragraphs on top of that explaining what we did. It kind of proves that we really didn't change the meaning. We just changed the way it's written. And to Andy's point, it's not always easy, but it is very, very important. And if you make that kind of informed case to the court that like, look, this is the same information just presented at a 5th grade reading level instead of 12th. If we didn't change the meaning, we didn't change the meaning. And showing our work really demonstrates that.
I want to highlight something you said about process. Mapping out the process is value in and of itself, even if you never get to that final product of a tool. We've engaged in this process thus far. We will get to a final tool for a particular set of forms. But in that process, we've been able to eliminate some forms because we've been engaging in the simplification effort with that as the primary purpose. So Aubrey, I really like what you said about purpose. The question I have is about trust and about trust in the information. You said that this is a separate link. And so I'm curious how you build trust into the form itself. Some people don't trust the court inherently, but if there's a way to build trust into this separate link, even if it's just, a click from a chat bot or something like that, how do you do that?
I think that's a good question. I would say that I think my guide dog is very trustworthy, but no, I think that's like still to be proven. And some of these, we expect that they'll be embedded in the court page, but like you said, not everybody trusts the court. I think one thing that we're hoping is that these are less formal and kind of can break down that interaction that can be from the court website that has like the seals and the judges, and brings it down into a space that is just comfortable and again like meant to be casual. It's important, it's serious, but they are more casual tools. It speaks in plain language. It is like a little fun, and meant to kind of bring it down and hopefully building trust in that it's serving their needs. It's not about the court's needs, it's serving their need and trying to do that in a way that works for them. But I don't know if you have thoughts.
Yeah, it's a fantastic question. And I think the kind of takeaway for me is trust is earned, right? So one way you do this is by involving all those stakeholders, as was mentioned, really building that community of understanding around what we're trying to achieve, putting it out there, and then your best ambassador always is someone who used the tool and liked it. That if you're thinking marketing, it's net promoter score, right? Would you recommend this to a friend? If they say yes, you've got something. If they say no, go back and figure out why. But that trust is earned and it develops over time. So we're kind of early days with some of these, and I fully take your point. Some people are just not going to trust the court inherently. Our hope and our goal is that by offering them something that speaks to them in a conversational tone, that takes into account what their goals and circumstances are and meets them in that place where they are and cuts through the noise of ChatGPT and weird YouTube videos, they'll see this and they'll say, the court is trying to help me. They're trying to give me a path to understand what's in front of me, and they're trying to give me a path to solve my problem. And if you do that and people see it and they like it and they tell their friends, then you've earned the trust.
Any other questions? One more.
No.
We love it.
Yeah.
I have a selfish question. I'm dyslexic, and so reading is actually pretty hard for me. Have you ever considered also adding a audio version to supplement the video? Because all of the stuff up here is you all have to read,
Yeah.
and about 20% of the population has a great deal of difficulty reading.
Yeah, it's definitely text heavy, and I think that's something that we think about, and sometimes it's hard to give everybody all the information. It's like we're trying to select only the information you need, but I think that's a great addition feature that could be available to play. I think we've also have the same thoughts on translation. All of these are only available in English because we are English speakers, but can also be translated relatively similarly. Additional thoughts?
And if you work with that plain language as a foundation, translation becomes much more affordable and much easier to do, obviously. But as I mentioned at the top, you're right. There are just some people that for who this will not work, right? And there are for some people what currently exists won't work. Some people want that video. Some people want the short video. Some people want the long video. Some people want a flow chart. Some people want a checklist. Our point with showing these off is to demonstrate the utility, but also to encourage you to think about an ecosystem of meeting those people where they are. Use the short videos, embed them in this. You can do that. Include it as an audio link, right? There are lots of ways to play with this, and I fully take your point. This is just one example of what we've got at the moment, but we are big fans of that ecosystem approach and figuring out kind of which tools are the right ones for the people that you serve, and they will find and self-select into the tool that works best for them, but you got to offer it.
Okay. It's the end of the day. I'm holding the microphone, so I'm going to ask the last question. Aubrey,
Yes.
we all know that memorable nicknames are really important. How do they come up with Tilda?
Oh, so I'm so glad you asked the question. So Tilda works, right? Like tenant, landlord, digital assistant. But one of our judges who's a champion of this work in Philadelphia actually has a dog named Tilda, and she's a little white dog, and it just happened. And really it started as kind of like a buy-in, but the digital guide dog was just too good. Zach came up with it.
What do you have to do to get judicial buy-in, right?
Yeah.
Whatever it takes.
Yeah.
Excellent questions from the audience. Thanks for sticking around. That was really engaging, and I appreciate that. And please join me in thanking our speakers. Sessions will resume at 9 a.m. tomorrow.
All right.
And please remember to go into the app and rate the session.
That's right. ours.
And follow us on all the socials. Good luck finding them.
They wanna
I look
talk
for them
more.
myself. But anyway, yes.
Please reach out if you need help. You have questions. You want to see these in a different way. You want to talk through it in your jurisdiction. We are happy to talk with you and happy to help. Thank you all again for the great questions.